It's time for Facebook Live. My name is Joe Nohavicka. I'm in Pardalis in Nohavicka. The topic is discrimination in the time of COVID. This topic came up, it was actually brought up to me by one of our star associates here, Demetrius. And he said, with the coronavirus now, all these employers have a reason to get rid of people who they thought were troublemakers, but were afraid because they thought they might get sued. And on the other hand, you have all these people who are not going to be afraid of getting fired because they have an excuse as well. And the example that Demetrius gave me was that, let's say if they had somebody, the employer had somebody targeted for termination, and that particular individual was in a protected class. Just for example, if they were pregnant, or at the time they targeted them, they were not pregnant, but they said, this person's a troublemaker, we're going to let them go. And weeks pass by, and then they make a decision to say, okay, you know what, next week we're going to let this person go. And during that 1 week, it's discovered that the HR department was notified by this individual that they were pregnant. What are they going to do? It's a really, really tough situation. I mean, they have all this material, all this proof that they have to support their determination to terminate this individual, but now this person is protected. All right, so they're in a quandary at that point. And if they called our offices, we'd have to say, honestly, this is not a good time, and you got to bite the bullet unless you really have hard facts to support your determination, to prove that you made this determination before you found out that the person was pregnant. In either way, you're asking for a lawsuit. This is legal advice. You are not going to lay that person off unless you're laying everybody else off in that department or in your company, because you are begging for a lawsuit. And right now the courts are, pretty much the state courts anywhere are on hold. And there are law firms waiting like hungry eels out there on the outside looking in, waiting for the wheels of justice to start turning so that they can begin their lawsuits. So you have to be very, very careful, okay, with this kind of decision. An employee is going to be hurt, obviously. Resentment sets in, and resentment, either it's from the employer's perspective or the employee's perspective, resentment is at the root of a lot of problems for everybody. Proving that an employer chose to terminate a particular employee for discriminatory reasons and not economic ones it's a difficult proposition. It's not really successful a lot in the context of wider layoffs that you see. So what does the employee have to do? In the example that Demetrius gave us, it's pretty easy. The employee is pregnant, so they're in a protected group. They just have to come forward with evidence that they're in the protected group and they got terminated for no reason, or no valid reason anyway, but for the fact that they were pregnant and didn't want to have to pay benefits or whatever the reason is, or they didn't want to have to worry about time taken off by the employee. That's really all that the employee has to prove. And then the employer has to come forward with evidence that it wasn't because of that and it had nothing to do with the decision, and it's because of poor performance, etc., whatever it is. And they better have really good proof of that. Otherwise, they're going to get popped. And that's when it gets really difficult in the time of COVID, where layoffs are just, they're just rampant. It's still going to invite lawsuits, and there's nothing that really we can do to prevent that from happening. But lawsuits are happening. And it's at this third step where the employees usually fail. Once the employer established that it laid off multiple employees, it's then difficult, if not impossible, to muster evidence that the worker was terminated not merely for reasons of economic necessity, but because of discrimination. And you don't want to have to defend these suits because, unfortunately, there's no inexpensive way to defend them. I'm going to give you a perspective from both the employers and from the workers as well, just so you understand what has to be done. So for the employers that are facing these tough decisions, they have to ensure that the employees are selected for termination based on objective and articulable criteria, meaning that it can't just be from their perspective, but from anybody's perspective. Any reasonable person would look at this employee and say, oh my God, this performance is unacceptable. And they have to articulate exactly what that unacceptable behavior was. So they have to prove objective and articulable criteria. Employers, business owners should aim to be able to show not only that the layoffs were economically necessary, but also that a particular employee was selected for inclusion in the laid off group for legitimate reasons. So if you're not laying off everyone, you have to make sure that when you separate these people into groups of the stays and the goes, that you have reasons that you can articulate, and they have to be reasonable. We just didn't like them, or we just felt that they were necessary. It has to be articulated clearly. They have to ensure that there's no disparate treatment among the employees subject to the layoffs. So any terminated employee should be treated in the same manner and provided the same communications as all other employees. So if everybody does their work in the office on a computer, and you have people working remotely, then you have to make sure that everybody is given, for example, a laptop, or they have access to a laptop or some kind of computer that they can access while they're at home so they can work. For employees who still have their jobs but suspect discriminatory selection practices are occurring, they have to take extra precautions to eliminate any possible justification for termination. So just for example, they're hearing that people are being fired and they suspect that they may be next. Those employees have to be very careful. Whatever your duties may be in the present circumstances while working from home or operating under a diminished capacity, whatever the case is, if you can, it would be advisable to give 110%. You have to make sure you're working at your absolute best so that they can't formulate some kind of reason, some articulated objective reason for firing you. So if you're at home, work hard, okay? You should save any records that could be relevant to your eventual claim, such as performance reviews, email correspondence with supervisors or coworkers. If your policy, your employment policy doesn't permit you to take any documents, then of course you can't do that. As far as your employee records, you should be able to access that and have records of that and just keep it. So, for example, if you have stellar performance reviews over the past 2 years, and then they say all of a sudden now when they're laying people off that they're letting you go or laying you off because of poor performance, you have strong support to show that it was discriminatory and not based upon actual performance. So even when working from home, keep in touch with your coworkers to maintain avenues for information sharing, and especially now more than when we were working together in the offices. If you're terminated, it would be important to have comparative data about employees who were laid off and those who were not. That's the basics of discrimination during this time. I'm going to take some questions now. Can employers take your temperature when you show up to work? I know it seems intrusive, but in this time that they actually would be able to do that. But they have to be doing it extremely carefully, and they have to be doing it to just about everybody. Let me tell you about carefully. If they're using one of the head temperature thermometers or whatever, they have to make sure that it's actually cleaned off each time, so that they're not being part of the spread themselves. So if you refuse to take it for that reason, that would be acceptable. But I think that they're smart enough to know that they're supposed to do that. Can the employee be asked whether they have COVID-19? It seems like that's very private information, but the answer is they are allowed to ask that question, and they are allowed to keep you from coming onto the premises for that reason. That would not be considered discrimination. It would be a valid way to protect the other employees. So the answer to that is yes. Can they ask if you have been tested? The answer to that is also yes. Can they ask about symptoms? The employee comes in and they have somebody at the front desk and they say, I guess the question is, do you have any symptoms of COVID-19? and the employee doesn't want to answer that question, they would be required to answer that question. That is definitely a valid question. Can they ask about whether a family member of the employee has been tested positive for COVID-19? That's a little bit different in that situation. And I don't have any statute or case law that would support that, but I would say that the better question is whether the employee has come into contact with anyone who has tested positive for COVID-19. This way, the individual family members at home are protected and the employer gets the information that they need. Can a 65-year-old employee be excluded who has no symptoms of COVID-19 because they are identified as part of the high-risk group? The answer is that they are under the Age Discrimination in Employment Act. These individuals maintain their protection. They cannot be treated differently just because CDC has made a determination that they are at higher risk. And I'll see you next week. I will have more for you all on employment discrimination. We have a lot of things to talk about, such as discouraging FMLA, intermittent leave abuse. That I wanted to talk to you about that, but I think that warrants an entire discussion. And I'll see you next time.